Good evening, friends. Amongst us, we have Yuvraj P, Narvankar, an advocate from Bombay High Court, who is also an author. While we say that he's an author, those who have been connected with Beyond Law CLC, they would remember that we did one session on one of his sessions, on his book launch, that is Electronic Evidence in the Courtroom, a Lawyer's Manual. I'm just showing that book. Those who have not bought it, they can actually buy it. It's a very good book, and we would like to understand what are the changes under the Bhartiya Sakhshya Adhiniyam, that is BSA, in respect of proving electronic evidence. Since there are certain changes, etc., we thought, why not call Yuvraj? True to his name, he rather emerged from Yuvraj to a king in the electronic evidence aspects of understanding. And that's why we keep on receiving requests that why not get ourselves understand the clarity in respect of electronic evidence. And thank you for joining us on a Sunday, despite the fact that one likes to move around. But the fact of his popularity is a thing different. Over to you, Raj, and thank you for accepting our invite.
Thank you so much, Vikas ji, for having me back here on Beyond Law. I must congratulate you on the extremely grown subscription base of your channel. Last time I had visited, I think it's almost twice of that. So I presume that many of the listeners would be new. So I will be doing this. Since I have spoken on this topic on the earlier occasion, I will ensure that I will not repeat much of what I had said earlier. But I will also not presume that the present audience is, they all have seen my earlier webinars. So it will be a mix of two. In the event if the listeners feel something is being repetitive and they have heard it on the last date, then they would pardon me for that. You can understand it will be for the new listeners. As Vikas ji rightly said, today we are going to talk about the Bhartiya Sakhshya Adhiniyam, something that we have brought today to replace an age-old act of Indian Evidence Act 1872, with which we had been put for, I think, more than a century now. And for all purposes, it was really good. Now, suddenly there was this change, and now we are going to grapple with the new challenges that the electronic evidence is going to pose at us, and we have to deal with them within the bracket of Bhartiya Sakhshya Adhiniyam. Let me tell you, the Bhartiya Sakhshya Adhiniyam, I think we already had a webinar on how does a Bhartiya Sakhshya Adhiniyam looks like. But let me tell you, so far as electronic evidence is concerned, my own thought about this is, what has changed in Bhartiya Sakhshya Adhiniyam is majorly about the electronic evidence. So if you ask me, I think almost 60% of the change, 60 to 65% of the change in the present Indian Evidence Act or Sakhshya Adhiniyam has to do something with the electronic evidence. And therefore, I feel the electronic evidence has been a soul of a change in this new avatar of Indian Evidence Act, Bhartiya Sakhshya Adhiniyam. And we are going to quickly go through what are the challenges that the new Bhartiya Sakhshya Adhiniyam is going to throw at us. Because we are entering into a completely different age of electronic evidence, and as we will go on exploring the new provisions and the effects it's going to have on our daily practice. See, Bhartiya Sakhshya Adhiniyam, Indian Evidence Act, always had, now this is for my junior colleagues who have joined the bar recently or who are going to join the bar. I always look at the Indian Evidence Act as a palace of having 4 doors. The first door is a door of a relevance. The second door of this palace is a door of an admissibility. The third door of this palace are the formalities for proving particular evidence. And the fourth and the last door, where actually this palace hall is the main hall, is what is called as a weight of the evidence or the probative value of the evidence. Any evidence to be of any use to a lawyer or a judge has to pass through these 4 doors of a palace. And then when it reaches the main santorium, then it is appreciated by the judge to arrive at a judgment. And therefore, evidence to go through these 4 stages has to pass through these 4 doors. If you ask me what Bhartiya Sakhshya Adhiniyam has done to these 4 doors, I would say the door of relevancy and the door of the admissibility has been kept intact in this renovation work of a palace. What has been replaced in this palace is the third door, and which is a formality of an evidence or a manner of a proving of evidence. Fourth door, obviously, the probative value and the weight of the evidence. has very little to do with the procedural law. It is more to do with the substantive law, because you always test the probative value and the weight of evidence on a touchstone of a substantive law, not on the procedural law. The first three doors are of a procedural nature. The last door is of a substantive nature. So to come back to a point, what the Bhartiya Sakhshya Adhiniyam has changed is the third door of the palace, and that is the mode, manner, and formality of proving an evidence. We are all aware the Indian Evidence Act was of consists of several chapters. The first chapter is of a preliminary, second is about relevancy, third is about the facts which need not be proved, what we call a judicial notice. The fourth is of an oral evidence, fifth is a documentary evidence, sixth is the exclusion of oral by the documentary evidence, our old section 91. And then we had chapter 7, which was a burden of proof, starting somewhere in the old act from 101, 102. And then we had estoppel starting from section 115. Then you had chapter 9 of witnesses, chapter 10 of examination of witnesses, and chapter 11 was of improperly admitted or rejected evidence, which only consisted of one section. Now only one chapter has been added in the Bhartiya Sakhshya Adhiniyam, which is the very last chapter, which consists of only one section, that is section 170. That deals with repeal and savings. That tells us as to what is the fate of the trial and the proceedings which are pending as on date Bhartiya Sakhshya Adhiniyam comes into force. And we will go to that part till later. The point I'm trying to make is, in these all chapters, what has essentially changed is chapter number 5. The chapter that deals with the documentary evidence. Let us start from the start. Let us start from the beginning. Section 1 of the Indian Evidence Act has changed. And I'm just talking, let me please keep this in mind. I will not be talking of a general Bhartiya Sakhshya Adhiniyam. That's not the topic of the talk today. It's electronic evidence. And therefore, I'll be only focusing and will be restricting myself to the changes that electronic evidence has brought in. First important change in section 1, if you see the old Indian Evidence Act specifically said in section 1 that this act shall extend to the whole of India. Now, this India word has been removed from section 1. And I think for a very obvious reason, if you look at any cyber offense or any electronic evidence for that matter, it knows no geographical barriers. It is bereft of any geographical barriers. A person sitting in Nigeria can hack into my system as easily as a person sitting in Mumbai. And therefore, the geographical barriers were always a limiting factor when you were looking at the evidence from point of view. So word India has now been done away with from section 1, from the applicability section. What was earlier section 3 in the Indian Evidence Act, which was called as an interpretation clause, has now been renamed, rechristened as definition clause, and it has been swiped with section 2. So now earlier section 3 has now become section 2. Now what has changed in this section is also very, very important. If you know, IT Act of 2000 brought several amendments, and one of the amendment was the old section 65B. That was the progeny of the Information Technology Act of 2000. Now, with the introduction of IT Act, the definition of the word document was not changed in the Indian Evidence Act. If you look at the old version, I'll request all of you to keep these two versions side by side, so you will be in a better position to appreciate. So Indian Evidence Act in its old avatar did not change the definition of the word document, but Bhartiya Sakhshya Adhiniyam changes the definition, which is what you will get in section 2, subsection D. And it defines the word document. And the word document was, so beautifully, I must say, thanks to the wisdom of the then legislators, was so beautifully defined in the earlier avatar, which said anything inscribed on any substance by any means is a document. A very simple definition and very wide in its ambit. Just imagine anything inscribed on any substance by any means is a document. So if you take a CD and if there is a laser beam on a CD, it will, etch the surface. So ultimately it is anything inscribed on any substance. So the definition of a document in its old avatar was capable of taking care of even a modern day CD or a DVD. However, the legislators thought it fit to add more clarity, and now they have added a specific definition, which is kind of a tail portion of this, and which says documents will include electronic and digital record. Now, this clarity, if you ask me, wasn't really required, wasn't need of a time, but that has been done maybe for a good reason. In the illustration, what they have done is also very important. they have gone on giving a specific illustration of this definition. It says that the word document now would include email, servers, websites, mobiles, laptops, smartphones, voicemail messages, and all that stuff. So now all these things, or even the CDR, what we call, the criminal practitioners call as a CDR, the locational evidence, is now also a document. Now, the definition of the word document has been expanded tremendously in the new avatar of the Evidence Act. Another change you will see within section 2 itself is section 2 subsection E. The word evidence has been now modified. Evidence, as you all know, includes primarily two things: oral evidence and a documentary evidence. Now, oral evidence has been specifically modified to mean it will include statements made electronically. So suppose if I'm sitting here, I'm giving a testimony in a court of law, that evidence, though it's an oral evidence, but through the electronic communication, it will still be regarded as an oral evidence, is now what, in short, the changed definition of section 2E will tell me. The word documentary evidence has also been, as I told you, has been changed to include now electronic and digital record. So these two important changes are what section 2 in the Bhartiya Sakhshya Adhiniyam has given to me. Now, rest of the sections from chapter 2, which is a chapter of a relevancy, which earlier used to start somewhere at section 5, which now begins at section 3, mostly it has remained intact, except the fact that there are few tweakings and few renumberings and few rearrangements of the sections, about which today we are not really concerned. Let us skip through this part and let's go directly to what is going to be the most important part of the topic today, that is section 57 of the Bhartiya Sakhshya Adhiniyam. Now, I must tell you one thing before I go ahead on this line. And again, for my junior friends, I always make it a point to highlight this difference. Please understand, we are today going to talk of electronic evidence, which is about admissibility of electronic evidence. As I told you, for my junior friends, please understand, admissibility of electronic evidence is different from the relevancy of electronic evidence, which is different from weight of electronic evidence. Let me explain you by giving an example. Suppose if there is an email that a lawyer sends to a client, and suppose if someone tries to produce that email in the court of a law, that evidence may be relevant because it maybe pertains to a case, but that will be inadmissible because the old section 126 around had prohibited the professional communications from being cited as an evidence. They were called as a privileged communications. So here is a case where the email is relevant, but it is inadmissible. Take another case where the evidence, the email between two persons may be admissible, but it is irrelevant to the case in controversy. So there is nothing in law that like privileged communication which stops that email from being admissible. So it is admissible, but it has nothing to do with the relevancy of the case. It has nothing to do with the case. So it is a case of an admissibility but irrelevant. So this is the second case we get. Third is called as a probative value of the email or the weight of the evidence. So email may be admissible, email may be relevant, but what the email really tries to prove, I'm giving an example of an email since we are talking of an electronic evidence. What the email is trying to convey, what the email is trying to prove is not of much, doesn't add much weight to the case. It's of no gain to the case, and therefore the weight of the evidence would be low. Or it may be an email recording something hearsay. Okay. So again, the weight of evidence would be, so hearsay may be, that email may pass through the two doors of relevance and admissibility and formality as well. Because if you accompany that email with 65B certificate, so it has passed through the three doors of admissibility, relevancy and formality. But when it ultimately reaches to the main hall of a palace, you may find that email is worthless for my case. So understand these differences, friend, that today we are going to talk an admissibility of an electronic record. That's what the old section 65B pertains to. If you look at the side margin in the BSA Act, you will see it's admissibility of electronic record, not the relevancy, not the probative value, not the weight. Let's come back to the topic. So section 57 is what was earlier section 62 of our Indian Evidence Act. As you all are aware, this section formed part of chapter 5, which dealt with documentary evidence. Now, primary evidence was very easy to be defined. Suppose if there is a book like this, and if this is a primary evidence, then what do I mean? When the document itself produced for the inspection of the court, it's a primary evidence, a simple definition. So suppose if I have a sale deed, a duly signed and executed sale deed, I call it a primary evidence. And the moment I exhibit that in a court of law, done is my job. Law will take its own course and the document will be marked into evidence. That was a value of a primary evidence, which is also called as a best evidence, because it doesn't require any further corroboration except proving the contents. So primary evidence was earlier a concept, so as to say, limited to documentary evidences, a paper document like this. Slowly, as the time advanced, we realized that documentary evidence forms a very minuscule part of the trial. Majority of the evidence consisted of devices like mobile, laptops, and communication devices. And therefore, to avoid any ambiguity and to avoid any kind of vagueness, the legislators thought it fit to include electronic record within the concept of a primary evidence. Now try to understand this. This is very important. The definition of primary evidence has not changed a bit. It remains the same. A document itself produced for the inspection of the court is a primary evidence. So far, so good. What has changed really are the explanations below the section. Now, the explanations below the sections, earlier there were only 2 explanations. Now you would see there are almost 7 explanations below section 57 which deal with the primary evidence. And the explanation number 4, 5, 6 and 7 are the explanations that are going to detain us for some time. Now, what do these explanations tell us? Please look at explanation number 4. Those of you who have a bare act, please, I'll try to convey the essence of those explanations and I'll explain what is the relevance of them. The first explanation number 1, 2, 3 are the old ones that we will not really discuss. Come to explanation number 4. Whenever an electronic record is created and stored, and when the storage happens simultaneously and sequentially, each of the copy is a primary evidence. Let me explain to you with an example. Suppose if this is a mobile that I am using to record certain event. Now, while recording this event, so you're all aware, if I'm using a mobile or like an iPhone, whenever I'm doing this, I'm ultimately, even this data is being buffered to what is called as an iCloud, correct? So there is a backup copy which is happening even with the Android devices. This process happens with every device. This happens where the backup copy goes on to what is called as a cloud storage. Now, what is happening? I'm creating and storing the data here, and there is a simultaneous and sequential copies made over at some other place. Now the law tells me that not only this is a primary evidence, but even that copy is a primary evidence. Let me tell you, in the old regime, this copy, the another copy on the cloud, could have been labeled as a secondary evidence, because you're all aware, section 63 of the old Indian Evidence Act, which defines secondary evidence, very specifically said copies made from the original by mechanical process are secondary copies, correct? And therefore, this copy earlier could have been eligible to be called as a secondary evidence, but the law now comes in and tells us, no, this is not a secondary, it is a primary evidence. Very important change, so as to say, when it comes to electronic evidence. And we will see what are the practical implications of this. Now, please come to explanation number 5. Explanation number 5 says that whenever an electronic or digital record is produced from a proper custody, then it is a primary evidence. Now, here there is going to be some discussion that we have to do, because it's going to be of some importance to the legal practitioners. What does it say? This is my mobile, right? I am the proper custodian of this mobile. If I have to produce this in a court of law, I will be the proper custodian and it will go from my end. So since I will fall in now explanation number 5, this will be a primary evidence in my hands. Assume for a minute I give this mobile, or without my consent, Mr. Vikasji takes this mobile and he tries to produce it. Maybe because it has got some relevance to his case. Now that's not a document that's coming from a proper custody, so it will not be a primary evidence in the hands of Vikasji. That's a concept. Now, where do I get the definition of a proper custody? You will have to refer to now what is section 81 of Bhartiya Sakhshya Adhiniyam. And to that section, you have an explanation which is good for section 81 and which is good for section 93. Now, what does that explanation tells me? The explanation in short tells me that a custody is called as a proper custody if it is in the hands of a person and at a location where it is supposed to be, or if the origin is legitimate or probable. In all these three circumstances, the custody is proper. Let me explain. Suppose if a theft occurs at my place, I don't have a CCTV cameras installed in my shop. But the next door ATM has got a very good CCTV coverage which records an event that is happening at my place like a theft. Now, I go to the shop, the ATM, the person in charge, I say, please give me the ATM footage. I need to, CCTV footage, I need to produce in a court of law. He may say, yes, I may take it and I may produce it. Now, though I am not the person who is in charge of that ATM CCTV footage, still the custody is a proper custody because the origin of this data in my hands is legitimate and it is probable. So I fall in the explanation to section 81 and therefore this will be called as a proper custody, a document coming from a proper custody. Let me pause here for a minute and let me analyze this. Because today when I'm going to discuss this, I also need to tell you what are going to be pitfalls and what are going to be the problems. I personally feel, and these are my strictly personal views, that this is a little problem in the new Bhartiya Sakhshya Adhiniyam. See, when I'm talking of a primary evidence, it has nothing to do with the custody. Suppose if this is a sale deed, and if it is a signed and executed sale deed, a registered sale deed, of original document, so to say. Whether I produce it, whether Vikashji produces, whether Mr. X produces, whether Mr. Y produces it in a court of law, this remains to be a primary document. So the primariness of a document has nothing to do with the custody of a document. You must understand this. However, the law has now sought to link the primariness of a document with the custody of a document, which is something unfathomable and inconceivable for a simple reason. That whether I produce this electronic record in the court of law or Vikashji produces that in the court of law, the vulnerability of this device being tampered is the same. The risk factor is the same. I can tamper it. I can tamper with this device the way Vikashji can tamper it, or whether some other person can tamper it. So me being a proper custodian of this device would not ipso facto ensure the integrity of a data, and therefore I, at my personal level, not able to connect the linkage between the primariness of a document and the custody of a document, because whether it is me or Mr. X, they will have to still produce what is earlier section 65B certificate, and they have to vouch for the correctness. So if you are ultimately putting it on a person to produce a certificate, where is a question of a custody then coming in? But let's keep that academic analysis at a side for some time, and we'll just continue with this, and then again we will come back to this. Please come to explanation number 6. Whenever a video recording, explanation number 6 to section 57, wherever a video recording is simultaneously stored in electronic form and transmitted, broadcasted, or transferred, then each of the stored recording is a primary evidence. Simple example I'll give you. Suppose if there is an IPL match which is being recorded at Wankhede Stadium in Mumbai, and it's being also relayed, at the other channels, then not only the local storage at Wankhede Stadium is a primary evidence, but the places where it's being stored after transmission, broadcasting, and transfer simultaneously is also, they all now are primary evidences. That's a simple meaning of the explanation number 6. The last explanation, which is explanation number 7, whenever electronic record is stored in multiple storage spaces in a computer, each such automated storage, including temporary file, is a primary evidence. Let me analyze this. What does it mean? See, whenever you are working on a computer, without you knowing, unconsciously, the computer is storing certain informations for your ease and convenience. For example, you would see while working, let's say you're drafting a writ petition, and the light goes off or something happens to your system, it gets suddenly shut. When you reopen your laptop, it will flash a message that do you want to save this file? You had not saved it. Now, where was it saved? You had not done it. It's not a conscious saving. It was saved in what is called as a RAM, random access memory. So RAM is a place where without you knowing it, it is stored without your manually you doing it. So that is called as an automated storage, the word that you will find in explanation number 7. Now, what is temporary file? Automated storage including temporary files. See, what happens is this. Assume for a minute, I am trying to work. If I am engaged into, let's assume if person X is engaged into what is called as a plagiarism. Okay, tampering with the copyrighted work and adding his own thing and publishing it as his own. Now, if suppose a person is engaged into plagiarism and he does not save the work on his hard drive and someone enters the room, he closes it without saving it. Still, the random access memory of that computer or of that device will contain the traces of the file that he was working on. It will also show what are the changes he made, what are the copies he has made, and what are the tamperings he has done with the data. Now, this is the significance of a RAM, that the user without knowing leaves behind a traces of an information which may be incriminatory piece of evidence. And therefore, the temporary files, see, whenever I'm saving a data consciously, it goes on to hard drive, what is a permanent storage. If it is happening unconsciously, it is going on a temporary storage location, which is called as a random access memory. Since we are on this topic, let me also give you a little bit of what is a forensic investigation angle to this. Always remember, whenever a device is running, the random access memory stores the information. Whenever a device is closed or shut, the random access memory will generally do away with the information. It will delete the information because it has got a smaller storage capacity. It has to get rid of the things. Why is RAM there? To give you the information quickly, so that access is quick. Rather than to retrieve it from a hard drive will take a time. From a RAM, you can just, it retrieve and it quickly. So RAM is there to assist the user in a faster use of a device. But therefore, a forensic investigator, when reaches to a site of a crime, they will never shut down the machine. They will first do what is called as a live forensics, so as to retrieve the data from the RAM, from a temporary file, because once you shut it, then that data is gone. Most of the time it's gone. So this was just a side note on what it has to do with the forensic investigation. Now let's go to what I will call the cornerstone of the Bhartiya Sakhshya Adhiniyam when we are talking of electronic evidence. And that's section 61 of the the Bhartiya Sakhshya Adhiniyam. Mind you, this section was not there in the earlier avatar. As you know, most of the sections are renumbered, rearranged, rechristened. This is not one of them. This has made its appearance in the book for the first time. Section 61 tells me, or rather removes a discrimination between this and between this. It says that nothing in this adhiniyam shall apply to deny an admissibility of an electronic and digital record just because it's an electronic and digital record. So please don't discriminate between the two. However, subject to compliance of section 63. That's a very important rider to which we will come back again. What does the section do? It says that please don't discriminate between documentary and electronic record. They are at par, they are equally admissible, and they will be equally legally enforceable, admissible, and will have an equal weightage as a documentary evidence. Now, there was technically no need, again, as in my opinion, to have this clarification, because once you escalate electronic record to a level of a primary evidence, it is understood that there is no more a discrimination between the documentary and electronic evidence. But be that as it may, today we have section 61, and now the discrimination and disparity between electronic and paper document has been removed. Now let's talk of most important section, which is nothing but rebirth of section 65B, which is section 63. And section 63 is going to be the topic for next half an hour. Section 63 is the place where most of the changes have occurred in the Bhartiya Sakhshya Adhiniyam. Section reads like as it was being read earlier. So before I go to section 63, let me give you a brief recap as to what was 65B and why was it there at all. Have you ever thought as to how we were dealing with the electronic evidence before 2000? Before 2000, there were computers, there were electronic records, but we did not have IT Act nor we had 65B. So how we were dealing with them? We used to call these electronic records secondary evidence, because if you look at again section 63, it says evidence can be given of existence, condition, contents of a documents where the original is not easily movable. So my computer and my server is a heavy device. I can't remove it and take it to the court. So Section 63 of the Indian Evidence Act allowed me to give a secondary evidence when the original is not easily movable. And using that small window, I used to prove the electronic record as a secondary evidence. That is what used to happen in pre-2000 era. When the year 2000, when 65B took birth, then the days of secondary evidence were over, and this was given a special status in the form of 65A and 65B. The first case arose in the Supreme Court was of a Navjot Sandhu in 2005, where the Supreme Court said that look at 65A, it says electronic record may be proved. So it is not shall. So you have still an option of going back to pre-2000 era and proving it as a secondary evidence. So from Navjot Sandhu started an era for almost a decade where 65B was virtually ignored. Till the point in the year 2014 when PV Anwar and Bashir judgment came, and it told us, the Supreme Court said, sorry, you cannot any longer rely on the era which was pre-2000, and you must now use what is in 65B, because 65B begins with the word notwithstanding, which is a non-obstante clause, and it will prevail on all the sections including 63, which is a second old section of the secondary evidence. And there began the era of compulsory observance and compliance of 65B. And therefore, it was held to be a mandatory drill to prove an electronic record. Shafi Mohammed came in 2017, which kind of diluted this mandate. Because, let me tell you why Shafi Mohammed diluted. Because the Supreme Court said, suppose this device belongs to me. Suppose Vikasji wants to produce it. He cannot get hold of me for 65B certificate, because if I refuse, then he can't get hold of me. So in this situation, you can relax condition of compliance with 65B, is what in Shafi Mohammed Supreme Court diluted the ratio of PV Anwar. But again in the year 2020 came the judgment of Arjun Pandit Rao Khotkar, in which Supreme Court restored what was said in 2014 and said, sorry, Shafi Mohammed is a wrong precedent. You must in every situation without fail comply with 65B certification. If I say no to Vikasji for coming to the court, there are ways and means to compel me to come to the court of law. May it be in the form of section 91 or any other section of the Indian Evidence Act like 165, old 165, you can compel me. So you can't cite an excuse from performance of 65B. So this was a quick recap as to how the era kept on changing till Arjun Pandit Rao Khotkar of 2020. Now let us look at what section 63 says. 63 begins again with the word notwithstanding anything contained in this Adhiniyam. And let me focus only on the changes. Any information contained in an electronic record which is printed on a paper or stored, copied, recorded in optical or magnetic media or semiconductor memory. Let me explain. The section tells me that electronic record which is printed on a paper. Suppose this is an email, I print it on a paper. For you, it is a paper, but for 65B or 63, this is an electronic record. Okay, printed on a paper, stored, copied, recorded in optical or magnetic media. Optical means CD and DVD. Magnetic means the hard drive or the floppy, as it was earlier. But one new addition has been made, and which is a semiconductor memory. Please mind you, the semiconductor memory was never ever part of the electronic evidence earlier. What is a semiconductor memory? It's like a chip, flash drive, like a pen drive, or our new devices which come with that flash memory. They are the ones which are called as the semiconductor memory. Earlier, it was not the part of a statute. Now it has been specifically made a part of a statute. So not only CD, DVD, and floppy disk, but also these flash drives will be a electronic evidence. And one more important word has been added, which is a residuary clause. Just look at the section again, section 63, or any other electronic record stored in any electronic form. So the law has now for good understood and realized the constraints of defining the genres, and it has now added a residuary clause. So everything that is not part of optical, magnetic, and semiconductor will now fall in the residuary clause, and it will be still called as an electronic evidence. The section reads further that these all electronic records will be deemed to be a document and shall be admissible into evidence. Mind you, admissible into evidence without further proof and production of the original if you comply with the conditions that the section mentions. So the document will be admissible, the electronic record will be admissible. That's first thing. Without further proof or production of the original. So many of my colleagues keep asking me that we produce the mobile, is it required for me to retain the original and produce the original? No. If you do a certification under 63, then or the old 65B, then there is no need to produce the original. That's what the section says. So always remember, the original is not at all a requirement. It was never a requirement, even in the old regime. 63 is a substitute for production of the original document, or the production of the original electronic record, may it be a laptop, may it be a mobile. Okay, so now what are those conditions? I will not bother you with the conditions. You can either hear my earlier webinar in which I have spoken in detail about those conditions, in what circumstances electronic record shall be admissible. I'll also give you a good reason of not revisiting those conditions, because as I will tell you later and explain to you later, you need not now really go into those conditions, because now the Bhartiya Sakhshya Adhiniyam has a schedule, and that schedule has a certificate, and that certificate mentions these conditions. So if you follow those scheduled certificates, there is no need to go back to these conditions. You can just simply take that certificate and produce it. So, but the conditions are the generic conditions. The computer output was produced by a computer in the ordinary course of business. It was used by the person having lawful control. As I told you, the discussions on this you will find in my earlier webinars. Please come to what is the most important part of section 63, which has changed a lot. And that is section 63(4) of the new Bhartiya Sakhshya Adhiniyam. It says, in any proceedings where it is desired to give us electronic evidence, then a certificate shall be filed along with the electronic record at each instance where it is being submitted for admission. Let me tell you, let me explain. Those of you who have got the old version of Indian Evidence Act, please grab a copy and see what 65B4 looked like. It did not say anything of this. There are 4 major additions which section 63(4) has done. First word, in any proceeding. So there has to be a proceeding pending if you want to file 65B certificate. Many of my colleagues used to ask me that if I am generating the electronic record today, I do not know that this is going to be used as an evidence in the trial. Then I did not make a copy of the certificate that time. Will it affect the admissibility of my electronic record if I am making the 65B today? Now the section answers it. In any proceedings where it is desired. So it contemplates a pending proceedings in which now you are going to give an electronic record. First major change. Second, the certificate shall be submitted along with the electronic record. Another query is addressed. Several times the queries were asked to me as to when do I submit the certificate. Is it along with the electronic record, or can I file an electronic record and subsequently file a certificate? No. Now the section is very clear. You have to do it along with the electronic record. Let me also caution you. There are judgments of State of Karnataka versus M.R. Hiremat or Arjun Pandit Rao Kotkar. I'll share all citations with Vikash and he will share that with you. Where it was said that no, you can submit the certificate even subsequent to the filing of an electronic record. Now I would say the legislator has taken care of it. It says along with the electronic record, at each instance you have to submit a certificate. Most important part comes at the end. Whenever you want to submit an electronic record in the court of law, the certificate shall be filed along with the electronic record where it is being submitted for admission. Please note the word where it is being submitted for admission. Why is it important? I'll tell you why it is important. In the law, if you come to Order 13 of CPC, Rule 1 and Rule 4, there are 2 important concepts. Production of a document and admission of a document. Production means I am merely filing the document in the court of law. It's a clerical act. Admission into evidence is an act where we are actually moving this into evidence, and this will be marked into exhibit. It will be read into evidence. A mind will be applied to it. And therefore, production of a document is one thing in law, And the submission, the admission into evidence is another thing in law, and section 63(4) tells me that the certificate shall be given at each instance where it is being submitted for admission, not for production. So if I want to mark, let's assume my email into evidence as an exhibit, that time I will produce this certificate. So question may crop up as to, do I do it along with the electronic record when I produce it, or do I do it along with the electronic record when I move it into admission for exhibiting? If you ask me, 63(4) seems to be dichotomous. It says along with the electronic record where it is being submitted for admission. So the section contemplates has little dichotomy. I will advise to you that it's better always if you do it along with the electronic record. I'll tell you the good reason there are little after some time. What is another good reason for this logic? But let me tell you, section also says that when you are moving it into admission, you can submit the certificate. Now, what does the certificate has to contain? It has to, obviously, the old thing. Again, you can go back to the lectures. I'm not really bothering you on something that I have already spoken, because I'm just today focusing on the changes. What it has to contain: identify the electronic record, the manner in which the electronic record is produced, or any of the relevant factors. So, अगर मैं suppose email produce कर रहा हूँ, then I will have to mention the device from which email print is taken, the server, my email server and browser, when I took the printout, which is a printer, make and model. ये सब जाएगा in 65 in the 63 certificate. Fine. Most important part comes at the end of 63(4), which says a certificate shall be signed by the person in charge of the computer or communication device or the management of the activity. Let me pause here for a minute. Many of my investigation, the law enforcement agency friends ask me, I am not the owner of a device. Suppose if I am a police officer, I go to a site, I find a pen drive lying over there. I am not the owner of that pen drive. I don't know who is the author of it, but it contains some incriminating evidence. Who will give the information? I am not the person. Let me tell you, the law does not require you. 63(4) does not require you to be owner of a device. The law is very clear. It says a person in charge of the activities at the relevant point of time, relevant activities. So if I am retrieving a data from a pen drive at, let's assume, on 1st of September, for the purposes of using it into my evidence, I am the person that 63(4) calls as a person in charge on the management of the relevant activities, because a relevant activity is retrieval of a data and producing it in the court of law. So please do away with the misconception that I need to be owner of a device, I need to be in charge of a device, I need to be administrator of a device. No, even if you are the one who can say with the authority and you can vouch for the correctness, you can be the one who can give the certificate, and we will go to the certificate itself and we will explain this. Okay, that's the first important part, that who has to sign it. Then, most important change again. Earlier, the certificate was to be given only by the proponent of electronic record. Now, who is a proponent? I want to produce this in the court of law. I am the proponent. Fine, I can give the certificate. That's how it was always like that. 65B was to be signed by me. Now, there is a regime of a dual certification. Now, what is a dual certification? It has not to be only signed by me. It has to be now signed by an expert. So, not only me who will vouch for the correctness, but expert will vouch for the correctness of that data. And this is what a certificate will also tell me. The certificate, as we will go little later, is divided into two parts. Part A of a certificate says that it's to be filled in by the proponent of an electronic record like me. And part B has to be filled in by the expert who will vouch for the correctness of the electronic record. So it has now the regime of dual certification. Let me pause here for a minute and tell you the practical difficulties for the practitioner. I understand in a criminal case involving a very high stakes, or in a civil matter of a high stake, it may be possible and practical to get dual certification. Imagine a villager who is going to the court of law with some piece of an electronic evidence like some WhatsApp message to prove his case. Do you think it's going to be very feasible for a villager or someone, who has a very remote access to all these technical advancements to get a dual certification? Earlier, if you remember, and I'll take you to that portion also, only when the expert evidence was required under old section 45 of the Indian Evidence Act, we used to summon the expert. Now, expert is mandatory and it has to be accompanied, he has to accompany the proponent of an electronic record. So villager must come armed with all these expertise to the court of law. Otherwise, the certificate is not followed and therefore there is non-compliance, and so goes out the admissibility of an electronic record is what the other side will argue. So I think this is going to be a little dampener, it's going to be a little problematic for the practitioners in the times to come, and we will see how to deal with that little later. So mind you, the certificate is now a dual certificate. It has to be signed by the proponent himself and the expert. Now, lastly, it says the certificate shall be in the form of a schedule given in the Bhartiya Sakhshya Adhiniyam. Okay. So the schedule has been given. Those of you who have the BSA Act handy, please look at the schedule. Schedule is very interesting. Schedule has two certificates, Part A and Part B. Because do you want me to just maybe share my screen so I can just explain the certificate properly? See, this is the first certificate. And you would see it to be filled in by the party. So this is to be filled in by the proponent. You will see what kind of electronic record you have to produce that has been enlisted here. It may be DVR, mobile, flash drive, CD, DVD. And इसमें से कुछ भी नहीं है, तो there is a residuary thing like other. Again, make and model क्या है, color क्या है, and all that you will have to say. Now, this is what I was talking of. The conditions in section 63(2) have all been drafted already and kept for handy use. So you don't need to really go back to one by one condition, that they're all here. Most important part, as I have written important, is here.
Raj, your screen sharing is not there.
I'm sorry?
Screen sharing is not there.
Oh, is it? The screen is not visible there?
Yeah, it's not visible.
No, it is saying only the host can share in the meeting. There is some problem. I'm very sorry. Anyways, so no, that should not detain us. I think the readers can just open the certificate maybe on their mobile and on the BSA Act, and I'll just go one by one. It's a very easy to understand. All it says, it gives us an option of whether the device is owned by you. It says if you are not the owner, is it maintained by you? If not maintained, is it managed? Is it operated? So as I was telling you, you have different options from which you can choose that in what category do you fall. Okay. Now there is what is called as, comes as a hashing. Let me tell you what is hashing. I really wanted to, maybe, I don't know if Vikash in the meantime can see if I can get the screen sharing control. I will demonstrate how the hashing is done, and I'll go to that little later. Or you can visit in earlier webinars. I have shown how the hashing is done. Hashing earlier was not mandatory. Now the hashing is compulsory. Now what is hashing? Let me again tell you. Hashing is nothing but a cryptography function. Suppose if I want to send my book to Vikash at Chandigarh, I want to ensure that my book is not tampered at all and it reaches as it is, as it leaves Mumbai. Not even a comma is changed. Now what option does Vikash have? He has to sit with a magnifying glass. He has to go threadbare and see there is not even a change of a comma. It is practically impossible. So what do? We invent something called as a cryptography. And what does the cryptography do for me? I have to apply an algorithm to my book which runs into 1000 pages, let's assume. And it will give me certain string of alphabets and numbers. Assume that it says M, D, K, M, L, V, some numbers. A string of 16 digits. Fine. I save it. I send that string. And what does the cryptography do for me? I send the string to Vikashji and send my book. All that Vikashji has to do is to reapply that algorithm to my book and derive again a hash value. If that hash value matches with the hash value that I had sent to him, then there is not even a change of a comma in the book. That's a testimony of the integrity of the data. This is in short what the hash value looks like. So it is a signature of a document. If it is not changed, the data is not changed. Or agar 10 terabytes के data में if there is a change of even 1 byte, then the hash value will change completely. There are 4 categories of hash values which are mentioned in the certificate. Let me tell you what are those categories. एक को उन्होंने बोला है MD5 category, which is nothing but a short form of message digest. Okay, MD5 is an old kind of a hash algorithm. There are all kinds of hash algorithms. You have to use either of them. Please don't use all of them. You have to use either of them. If it's possible, use SHA2, which is the most advanced and most secure form of the hash algorithm. It is called as a secure hash algorithm. Again, let me tell you, it's very easy to generate a hash value. Let me tell you how to do it. I'll just see if I can now get to maybe do the screen sharing. If I do it, I'll show you immediately. No, I think there are some issues again. Okay, anyways, all you have to do is to please go to Google. Please go to Google and type hash value generator. Simple. The first result itself, it may be any website, you please open it. And there you can upload any file from your laptop or mobile. Let's say you take any image of yours, any photograph saved in your mobile, you upload it there. It will give you MD5 hash value. It will give you SHA1. It will give you SHA. You will get 3 hash values generally. Now आपको image में थोड़ा change करिए. And you re-upload it, you will see the hash value will be changed. A simple exercise you can do at your place. Just go to Google and type hash value calculator, HASH hash value calculator. Very easy exercise to do. My book has all these technical details, but this is something that is easily doable. The reason I'm telling you this in detail is now you will have to do the hash value thing in every single case, which was not earlier the case. Hash value was not part of a certification. Now it is a compulsory part of a hash value. It has to be a part of your certification. You have to do it. One word of a caution, very important. If you are dealing with the sensitive cases like POXO or some sensitive cases, please do not use online hash value calculators. There are offline apps. आप कोई भी app में store में जाके you can download what is called as a hash value calculator. The reason is many of the websites retain the data that you upload on them. So if it's a sensitive data, it is likely that that may be misused. Okay, or it's a copyrighted information that may get leaked. So please ensure that you use offline hash value calculator for purpose of demonstration and understanding. You can use the online one. Fine. Now hash value आपने किया. Suppose if it's a message on my mobile, मैं उसका folder बनाया, मैंने उसका hash value निकाला, मैंने वहाँ पे लिख दिया. 2 very important warnings to you. Please understand, there is something called as a hash collision, which will never happen. It happens in rarest of the rare cases. See, the law is the technical law, if I may say, the rule of a technology is that 2 hash values will never be same if the data is different. Okay, so if, as I told you, even if the comma is removed, the hash value will completely change. Sometimes happens hash collision जहाँ पे 2 different data का hash value same आता है. But as I told you, that is 1 in a billion case, so you don't need to worry about it. You should just know it is a matter of, it is a possibility, what is called as a hash collision. Second, always remember hash will change like this, just like this. I'll tell you how does it happen, and that's going to be a problem and headache to the practitioners. मैंने ये image बनाया, I produce it in the court of law. मैंने उसका hash value भी दिया. Fine, so far so good. कल जाके आपके ओपोनेंट ने बोला कि नहीं, मेरे को एक हैश वैल्यू मेरा अलग बनाने का है. यू सेंड मी, आई वांट टू टेस्ट द इंटीग्रिटी. यू गिव मी द डेटा. व्हाट डू? You go to a laptop, you put a pen drive, you copy the file and you give it to me. Let me tell you, the hash value will be different, and I'll tell you the problem. Problem is there are 2 kind of copies in the electronic record. First is called as a forensic copy. Second is called as a simple copy. Simple copy means मोटा मोटी, let me use that very generic word, मोटा मोटी जो है वो जाएगा. The simple copy. Okay, so the computer wants to save the data always. It's always data saving is the primary aim of a computer. Okay, so what it will do, it will reduce the resolution. You will see many times आप WhatsApp पे photo भेजते हो वो तो blur आता है. Why? Because the data, to save the data, the resolution is brought down. When the computer or a machine does it, hash value changes because there is some difference, technical difference and technical change that happens at the back end, and therefore the hash value changes. If you want to have an exactly same hash value, that is called as a forensic copy, which is also known as a bit by bit copy. And if you do that, then the hash value never changes. So I will request all the public prosecutors that if you are giving a the data to the accused, if it's in the form of a charge sheet, always give a mirror image. Insist to the person that please you go to a technical expert, request him, sir, mere ko mirror image do. That's called a mirror image as well. And if you want to have a very good illustration on this topic, it is in a judgment of Dharambir versus CBI given by Lordship Justice Muralidhar, as he then was, where he distinguishes how the forensic copy looks like, how a bit by bit copy looks like, and how it is right of an accused to get the copy, forensic copy, so you can do the analysis on it. So always remember, agar aapko hash value mein difference dikh jaye to chaukiye mat. That is possible sometimes because of the simple copy and a forensic copy. You should know this difference. Also, there is also concept of a chain of custody, and let me deal with that concept here only. If you know the BNSS, Bhartiya Nagrik Suraksha Samhita, which was our earlier code of criminal procedure, had a section in the form of section 173 that dealt with charge sheet. Now that section has been renumbered as section 193 in the BNSS. That section has got a very interesting and novel concept which was not earlier there, which is called as a sequence of a custody. So अगर आप police machinery हो or law enforcement हो, and if you are submitting a charge sheet, you have to also give there what is called as a chain of a custody or a sequence of a custody. What does it mean? I'll give you an example. Suppose in my office, right outside happens certain incident that my CCTV captures. Fine. My first source is here. Police comes to my office and acquires the evidence. Second, police give it to the forensic lab. Third, forensic lab gives it to the IO after analysis. Fourth, IO gives it to PP. Fifth, and PP files it in the court. Sixth. So the data changed the hands 6 times. This is called as a chain of custody. Now the law tells me that at each of these stage, you will have to technically give what is called as a chain of custody form. So whenever the data changes the hand, you have to give the certification. And that has to contain what is called as a hash value. So you can ensure that what goes out from Yuvraj's office is the same data that reaches the court, and that can be proved and established only when all these hash values match with each other. Correct? However, assume for a minute that my CCTV captures an incidence of 1 hour, और उसमें से खाली 2 minutes का relevant है footage. The incidence is lasts for 1 hour, only 2 minutes evidence is relevant. IO में think कि मैं इसको trim करता हूँ, खाली वो जो important है मैं forensic को भेजता हूँ. Okay, I will trim the rest of the data. So what is he doing essentially? He is changing the data and therefore changing the hash value of the data. And there is going to be now a major difference. Sorry, word major may not be a right word because difference is difference. So there is a difference between 2 hash values, and the defense may argue that look, there is a difference. IO should be in a position to explain that why there is a difference. And he can very well put it on an affidavit that the reason of a difference is this, that what I had is a simple copy, what was given to was a simple copy. Or what was acquired by me was an entire footage, what was given to him is only a trimmed version. So you should always have a justification for a change of a hash value. Otherwise, your data integrity is under a cloud of a doubt. Most important part, you always please remember this. And therefore, chain of custody form has to be meticulously maintained, at least in a criminal prosecution, because now 193 mandates you to have it that way. Coming to the last part of our talk today, which is section 81, to which we briefly referred when we were talking of section 57, explanation number 5. Section 81 tells me, and this is going to be of a great help to all of you, because the section says that the court shall presume genuineness of every electronic record if it is kept substantially in the form that the law requires it to be, and if it comes from a proper custody. Why did I say it's going to be of use to you? I'll tell you. Sometimes it may happen that you are not very thorough with all these formalities, and आपका यहाँ उधर कुछ 19-20 होता है. Let's assume that. Section 81 tells me that the law shall presume, the court shall presume genuineness of every electronic record which is substantially kept in the form. Now, word substantial is very important. So it need not be to the hilt compliance. It may be a little less. Obviously, it has to be inadvertent. It has to be a minuscule. It should not be a complete bypass of a procedure. But if it is substantial in the form, then yes, you can still invoke section 81. Again, it should come from a proper custody, and we just discussed what the proper custody is. So section 81 will reduce the evidential burden on the person, on the proponent, to a greater extent if he can prove that I had kept the data substantially in the form that the law requires it to be. Then comes section 93, which is a very easy section. You can just maybe open the book. It says that the electronic record, if it is more than 5 years old, the court will presume that the signature, the electronic signature, has been put by the person who purportedly has put it. That's okay. Let me address you something on a very, very important concept. Who is an expert? We saw that a certificate has 2 certifications, one by the proponent and one by the expert. Now the question arises, who is this expert? For that, you please refer to section 39(1) of the Bhartiya Sakhshya Adhiniyam, which is nothing but renumbered section 45 of our old Indian Evidence Act. This section tells me who is an expert. The section earlier had only 4 fields. I think it had the foreign law, art, science, handwriting, and fingerprints. Now it has got a residuary clause. It says, or any other field. So a person, even if has some expertise which is not enlisted in the section, it is taken care of by the residuary clause. So the expert that is referred in this 63, the certificate expert, is nothing but this 39(1) expert, who has to be a person having special skill. Now, who is this person having a special skill? Law does not say anything. It may be a person with a BE degree, BTech degree, some diploma, or who is expert in acquisition of an electronic record. Fine. He can give the certification. Many of my colleagues say that, no, it is this expert is not that expert. The 39(2) is the expert that section 57 contemplates. Please look at section 39(2). It talks of examiner of electronic record. It was earlier section 45 capital A of the Indian Evidence Act. What 39A says, when in any proceedings the court has to form the opinion about electronic record, the evidence of an expert under 79A of the Information Technology Act will be relevant. Please note the word in any proceedings. So 39(2) is of relevance only when there are pending proceedings. 39(2) will be of some import. Again, 79A we are referring to IT Act. Let me tell you, IT Act has section 79A, which has got certain notified laboratories in India. And if you want to prove an electronic record, you have to, the prosecution or the judge can refer it to those forensic laboratories. But they have to be a notified lab under 79A. Now, मेरे बहुत से दोस्तों का ये कहना था कि no, 39(2) is the expert who has to give the certificate of a schedule. Let me tell you, that is not the case. Fortunately, that is not the case, because it is impossible for us to refer it to a notified lab in each and every case, because Evidence Act is equally applicable to civil case as it is applicable to a criminal case. So suppose if I want to prove this email in the court of law in a suit for a specific performance, it will be absurd to expect me to send it to a forensic lab to get my certificate of section 63. So this is not what the section at all contemplates. It will make it unworkable. That's point number 1. Second, 39(2) talks of an electronic record. 63 talks of any information even printed on a paper. So section 63 is a very wide in its ambit. 39(2) is a very narrow in its ambit. 39(2) will come if the court wants to summon an electronic expert. Then only 39(2) will be of relevance. Assume for a minute, prosecution says, this is the version. Defense says, no, this is the version. Then the court may invoke 39(2) to send it to a forensic lab under 79A and then call for the report. There 39(2) will be of some importance. If you are talking of a certificate as annexed to the schedule, in the schedule, then 39(1) is the expert, who can be any expert possessing any skill. Also, let me address another query here, which is rampantly asked as to, can a same person give both the certificates? My respectful answer would be no, it cannot be. The whole purport of having 2 certifications is that one should vouch, the expert should vouch for the correctness of what the proponent says. If the same person gives both the certificates, then the whole legislative intent gets frustrated. So expert has to be the person different from the proponent. Who can this expert? As I told, any person possessing any special skill can be an expert. but he must possess a skill. He cannot be any random person. Now let me, for the last 5 minutes of this talk, let me address few difficulties that a practitioner may encounter. As I told you, I think most of them I have addressed, that the same person cannot do both the certifications. Get any expert to do the certification of part B. Sometimes you will find yourself tricked in a situation. Suppose if this is a print of an email, okay, section 63 tells me any electronic record printed on a paper, correct? So it can be even printed on a paper. So even this is an electronic record if it is a print of an email. अब इसका hash value कैसे निकलेगा? This is a paper. This is not possible. You will encounter these situations. There you will have to hold to your grounds and deal with those situations based on the contingency. There you can either scan this record and make a hash value. You can just get this scanned, or if suppose original email is there, then you are fortunate. Then you can get the original email copied and get it hash valued, and then you can submit a hash value. If the original email is destroyed, all you are left with is, if it's a paper, then you can file an affidavit saying it is impossible for me to get the hash value for these reasons. In Arjun Pandit Rao Khotkar, you will find a para by Lordship Justice Nariman, as he then was, where he invokes a doctrine of law does not compel the impossible. There is a Latin maxim to that effect. So it is impossible for you to do something, impossible for you to get a certification like this, then you are exempted from the performance of it. But you will have to prove that to the hilt along with an affidavit wherein you have to set out in detail what are the attempts you made and how have you failed in spite of those attempts. This is very, very important. Then last question that I will answer on my own and then we will open it for question and answer. When you have to keep it ready, always keep it ready when you, as I already said, when you produce it or you admit it in the court of law, it is better to, another question, when I have to keep both the certificates ready, can I first prepare my part A certificate because it's me who has to sign it, and can the certificate B of part B be given later? My request to you will be, don't leave much of a time difference between these two certifications because the hash value may change. So अगर आपको मालूम है कि मेरे को ये evidence court में exhibit करना है, I have to produce it. It's good that you have your own hash value done of part A and keep it ready. You have to also approach the expert and get the hash value done on the very same day. So there is no dichotomy, there is no difference between the two hash values because certificate has got two hash values. Part A also has a hash value which has to be calculated by the proponent. Part B has a hash value which has to be calculated by the expert. So I do not want a situation where there is a dichotomy between these two hash value which will undermine the integrity of an electronic record. So it's always better that you do it on the very same day, though the law does not define a time frame when you have to do it. So friends, with this, I think most of the electronic record that we have covered, apart from there are very few minor changes, that the electronic copy of judgment is now relevant, electronic gazettes are relevant, because in the BNSS there are too many changes about electronic. You take 85 of BNSS, you say take section 105, you take 176, 173, you will find audio-visual recording has been made now compulsory. So corresponding changes have been now made in the Indian Evidence Act, but they are very nominal and very, I would say, administrative. They will not have much substantive bearing on our day-to-day practice. The ones that had a very substantive bearing is what we discussed today. So thank you so much for being here. And I open it for the question and answer session. Over to you, Vikash. Let me answer in the meantime the questions which I can see in the chat box. What is the validity of a hash value generated from a website? No, let me tell you, there is absolutely no problem to get it online. The one that you get from online resources will be the exactly same that you get from the offline resources. There are no differences. The only reason I discourage the online is to have a sanctity of your data maintained. That's the only reason. Otherwise, they are fine. Hash value under 63 of BSA versus hash value result under section 3 of the IT Act distinguished. No, they would be the same. There won't be any difference. Hash value is a mechanism of foundation. So technically it would remain the same. And as I told you, don't worry too much of a hash value. You do it in a way best possible manner, and you always have an affidavit ready whenever it changes. You should be able to explain the change. And if you do it, and if you prove it, that I had kept in substantially in the form that the law requires, you will get help of section 81. So you always keep it handy. Yes, thank you so much. Yeah, any next question in the chat box, or if Vikash can put it.
Another is, does the hash value change with time if no change has been made?
Absolutely no. A very good question. Hash value will remain unchanged even for decades together. But as I told you, if it changes, and see, I'll tell you, hash value is a very risky and very slippery, where without even you realizing there might be some change, and it will change like that. So you have to be very cautious of not letting it change. And the only way to do it, as I always keep telling to my friends working in police, is to always maintain one master copy of a data and never touch it. आपको जो भी काम करना है वो उसके फर्स्ट कॉपी पे करिए, सेकंड कॉपी पे करिए. यू मेक मल्टीपल मिरर इमेजेस, एक ओपोनेंट के लिए करिए, एक जज के लिए करिए, लेकिन मास्टर कॉपी को कभी हाथ मत लगाइए. तो मास्टर कॉपी, सो डाउन द लाइन, if there is any change in a hash value, you should be able to argue in the court, look at my hash value of a master copy, it is exactly the same. I don't know what has gone wrong with the subsequent copies. Look at the master copy. So always keep master copy intact. Yeah.
This is by CS Rao. Yes. When we obtained photo prints and submit which are taken from the mobile phone, whether we get hash values of photo prints or photocopies into micro SD card from mobile.
No, sorry, I did not quite get it. Can you please, Vikashji, repeat or explain?
When we obtain photo prints and submit which are taken from the mobile phone, whether we get hash values of photo prints or photocopies into micro SD cards.
No. Let me tell you. Suppose if you want to take a printout of a photo which is on your mobile, you will not first take a print and get a hash value of a print. The process will be like this, that you will get a hash value of a soft copy first, and you will mention that in a certificate. And then you will take a printout for the perusal of the court, for the convenience of the court. You will not be able to technically do it on any hard copy. The hash value is a concept only restricted to a soft copy, and you will have to do it on a soft copy only and keep it intact. And for administrative convenience, you can, as you do the transcript, you can keep the printouts ready and handy.
Do we have any hash value software to avoid serenity of the data?
I have mentioned few in my book. I have also given the procedure. I have recommended few names, but let me tell you, to be very frank, there are no standard softwares. The hash value, fortunately, is an algorithm which does not really change as per the programmer or the companies. It will remain the same. So no specific software. You can use any decent one.
This is by Veronica. How to prove that while trimming, no tampering has been made?
No, it's not difficult. It's not you can't be proving it. It's very difficult to prove that there is no tampering. If there is a trimming, all you have to do is to mention the fact of a trimming. If possible, you can do the screen recording of the process where you do the trimming. Or the safest part is you have a hash value of the entire data intact. You have a hash value of the trimmed data stored separately, and be very candid to the court and say, this is a hash value of the entire data. This is a hash value of the trimmed data. Please don't mistaken it as a tampering with the data. All I have done is the trimming. And you can always file that additional affidavit. Yeah.
This is by Anirudh Tyagi. If a party records on his mobile phone, the CCTV video recording means the original recording is on the CCTV storage. Will that recording on mobile phone also be considered as a primary evidence?
Yes, it would be now, because if you look at explanation number 5, it says copies made simultaneously or sequentially. This will be now a sequential copy of the CCTV data. So it will be also an electronic record. But let me tell you, friends, I think I skipped that point. Don't get too much enamored by this primary evidence and secondary evidence, because see, the whole concept of making an electronic record as a primary evidence was to do away with these formalities. Unfortunately, the legislators, on one hand, making it a primary evidence, have still retained what was an old school 65B. So I don't understand the logic. of elevating it to a status of a primary evidence and still retaining the formalities of 63. Because the law from which in UK we derived all this has been done away with long back. But anyways, the section still retains. So don't be under impression कि ये primary evidence है तो I'm exempted. No. Look at 61. 61 says subject to section 63. So 65B and 63 will be a compulsory drill.
This is Kerala man anywhere. If the expert in part B must be an independent expert, or can he be from the propounders organization?
No, it can be anyone. It will be mostly a party-sponsored expert, so to say, because you will have to get him along with you. And he may be subjected to a cross-examination since his will be an affidavit. So yes, it can be any expert as long as, whenever he's put in a cross-examination box, he should be able to answer few queries that the cross-examiner will put to him to test his expertise. If he's able to answer those queries, any person is good to go as an expert.
Deepak Mehta, he seems to be the law officer from State Bank of India. He says whether bank statements are required to be submitted with Section 63 subclause 4 or Banker Book Evidence Act itself will work.
Bank statements, no, will be governed by, as you rightly said, the Bankers Book Evidence Act.
Or Banker Book Evidence Act.
Which evidence?
Whether bank statements are required to be submitted with Section 63 subclause 4 or in terms of Banker Book Act.
Correct. Because it will be as per the Bankers Book Evidence Act, because there have been corresponding amendments along with IT Act of 2000 also to the Bankers Book Evidence Act, which are still intact, and therefore that will have to be accompanied by the Bankers Book Evidence Act certification.
Law is also to the effect that special act will prevail over the general act.
Correct. And the case was, as someone has mentioned on the chat box, yes, I think I had shared with Vikashji. I'll do that again. No worries. I'll do that.
We will share it on the website also.
Sure. Instagram live videos, yes, will come under explanation 6 of section 57. Yes, perfect example of explanation 6.
Probably this is our 4th session with you, and I have realized that your Hindi has gone this time more smoother than the Marathi tone. So I will say that give a 10 minutes wrap up in Hindi so that people can watch it also. Who are watching it can understand the nitty-gritties in the
Now you want me to just give it?
Yeah, just 10 minutes wrap up. You are taking it off.
No, but because you'll have to pardon me for my Hindi. That you please don't pin me down to my Hindi.
I can understand it can be Hindi English mix, but
I'll just in a 5 minutes. I'll do that. I'm happy to reach out to as many people as possible. I'll do it. The point इतना ही है बस कि 63 जो है वो 65B का ही I would say नया अवतार है. इसमें कुछ फर्क नहीं है. आपको खाली सर्टिफिकेट जो है उसको फॉलो करना है. सर्टिफिकेट में 2 पार्ट है, पार्ट ए पार्ट बी. पार्ट ए आपको देना है खुद को, पार्ट बी एक्सपर्ट को बुला के देना है. ये एक्सपर्ट कोई भी हो सकता है जिसको वो विषय की जानकारी है, जो एक्सपर्ट है उसमें. ही कैन बी द एक्सपर्ट. उसको आपको खाली कोर्ट में लाना पड़ सकता है अगर अदर साइड क्रॉस एग्जामिनेशन के लिए इंसिस्ट करे तो. अगर आप वो एक्सपर्ट की टेस्टिमनी लेके आ सकते हो तो दैट विल बी द ग्रेट थिंग फॉर द एज अ बूस्टर फॉर द इलेक्ट्रॉनिक एविडेंस. एंड द हैश वैल्यू मैंने आपको जो एक्सप्लेन किया तो यू कैन जस्ट रेफर टू द हैश वैल्यू पार्ट. बाकी देयर इज एब्सोल्युटली नो चेंज. कोई भी फर्क नहीं है. जो पहले का था वैसे ही है. खाली प्राइमरी एविडेंस अभी बनाया है इलेक्ट्रॉनिक एविडेंस को, जिसकी वजह से उसका जो ऑरा है, जो लेजिटिमेसी है, वो अभी डॉक्यूमेंट्री एविडेंस के तरह ही है. फिर भी आपको 65 भी जो पुराना था उसके तहत सर्टिफिकेट देना ही है. खाली सर्टिफिकेट अभी आसान है क्योंकि वो हर केस में नहीं बदलेगा. आपको एक स्टैंडर्ड फॉर्मेट यूज करना है और उसके हिसाब से जाना है. So that was a quick recap of what we discussed today. Thank you. If there is an objection to the copies produced, will production of the original device be compelled? If yes, it is advisable. No. A very good question. कि अगर किसी ने ऑब्जेक्ट किया तो मेरे को ओरिजिनल करना पड़ेगा क्या? I'll tell you the therefore I focused on those words. The section 65B and now 63 says without further proof or production of the original. So you will argue within your rights. Many a times I have seen lawyers raising these arguments कि ये तो मोबाइल का प्रिंट आउट है, मोबाइल ओरिजिनल का है, उसको बुलाओ. No. When law gives me an exemption from producing further proof and the original, you cannot compel me to produce the original. There is only one exception, that is section 7 of the IT Act. Section 7 of the IT Act says when the law mandates that original has to be preserved then only the original has to be preserved. In other cases, the original need not be preserved. For example, जो अपना CDR data होता है, तो UAPL license के तहत telecom companies को preserve करना पड़ता है for a certain duration. Those are the cases where the law compels you to preserve and retain the data under Section 7. You, as an ordinary, you and me are not bound by any law which compels us to preserve ये mobile में iPhone आज कल बदली कर सकता हूँ, कल इसको बेच सकता हूँ. The law does not compel me to retain it. So no one can compel me because 63 tells me without further proof and production of original. So you can say the moment I have given the certificate, my burden of proof is discharged. You cannot compel me to do anything further. So that you can order. Thank you.
Large number of the chat box says that it's a very highly informative session.
Because I can see one by cable at the stage of summons notice report, which was issued to the accused to WhatsApp. How to prove that before court? WhatsApp, you have to take a print, maybe a hash value. You file an affidavit of service, what we call it here in the Bombay High Court, Supreme Court. You can file an affidavit of service to that. You can annex it along with your certification. So that will be a good proof. Yeah.
Thank you, Mr. Yuvraj. I'm quite sure that this session will be loved as the previous sessions. And those who have missed the previous sessions can always like, subscribe, and share the YouTube channel, and also watch these previous sessions, not only of Mr. Yuvraj, but other sessions also. We have more than 700 sessions out there. Do stay connected with us. Everyone stay safe and stay blessed. Thank you. Namaskar.
Thank you. Thank you.